Hello and welcome to Liberty Law Talk. I'm your host, Richard Reinsch. Liberty Law Talk is featured at the online journal Law and Liberty, which is available at lawliberty.org. Hello, this is Richard Reinsch, welcoming our guest to Liberty Law Talk today, Lee Strang, author of Originalism's Promise, a Natural Law Account of the American Constitution. Lee Strang is the John W. Stepler Professor of Law and Values at the University of Toledo College of Law. He has written and published widely in originalism, constitutional law, and natural law subjects. 2018, 2019, he was a visiting fellow at the James Madison program at Princeton University. Lee, we're glad to have you on the program.
Thank you so much, Richard.
So thinking about this book, Originalism's Promise, and what drew me to your book also was the subtitle when I first saw it, A Natural Law Account of the American Constitution. So we'll talk about both of those subjects and how you fit them together. But maybe here at the beginning, Lee, what do originalists want?
What do originalists want? I think it's changed in some ways over the decades of modern originalism's revival since the early 1970s, but some things have changed the same. So some of the things that have changed is the end state towards which originalists argue originalism leads. So there's been a flourishing of scholarship, especially since the late 90s. Professor Barnett's book coming out in the early 2000s about providing for the protection and establishment of natural rights. More recently, John McGinnis and Mike Rappaport's book, Originalism Leads Towards Good Consequences. But I think one of the things that you see in all of these different moves, all of these different normative accounts, is that a reason or the reason why originalism leads to these different state of affairs, and this is the consistent part over the years, is because it provides, on balance and overall and systemically, a relatively determinate way to access the Constitution's legal meaning and then to implement it over time. And that has the kind of corollary that many originalists, although not all, identify, which is that judges are able to identify and then follow and then be criticized for not following the Constitution's original meaning. So I think there's been some change over time, but I think the key insight that originalism offers is that it allows Americans, and especially judicial officers, to see the Constitution as a legal document that's judicially enforceable in a principled manner.
So think about this, more about the change within originalism, because as I was reading your book and other accounts of originalism, had on another author a couple of years ago with a new book on originalism. And when I was an undergraduate, when I was in law school, not that long ago, and for some years after, I thought I knew pretty clearly what originalism was, and I thought I knew pretty clearly who my opponents were. They were the living constitutionalists, they were the progressives, they were those for whom the text was an occasion for invention, for construction, for the development of new rights, or the diminution of things clearly in the text. And I thought, well, those are the people that I'm trying to defeat with an original meaning. Sometimes hard to locate. We could have a discussion and a debate amongst originalists about what the meaning was of provisions and clauses in the text, but we all knew we were in the same enterprise. I no longer think that when I think about originalism now. In fact, and I don't think I'm unique in that regard. It seems to me there are many camps and philosophies within originalism. You write about those in your book. You write about even a progressive originalist at Yale Law School, Jack Balkin, and his school of originalism jurisprudence, which is giving voice in some way to popular constitutional movements. That's a succinct description, but you can elaborate more on that. And how do you see it? When I think about, the libertarian originalist, and then of course there's original meaning, original intent. You talk about that, various schools within that. There seems to be always, though, politics lurking here, even though originalism claims, or I always took it to be a claim that we're not about politics or an end, we're about understanding the Constitution itself?
Yeah, Richard, that's a great question. It's one that I've been thinking about, especially since reading a chapter by Steve Smith, maybe 4 or 5 years ago, in a collection that was called "The Challenge of Originalism," and Steve had a chapter in there titled, I think it was "Give Me That Old Time Originalism,"
Yeah.
and it had lots of theological and religious connotations and references in it as well. And basically, what he said was something similar to what you're saying, that there's the old time originalism, which was simple, which had the connotation of being pure and consistent, relatively easy to identify, relatively easy to implement. And then now you have today, where you have a cacophony of people claiming the mantle of originalism, but seeming to do things and have commitments that don't seem to be consistent with each other. So I think it's a live issue within originalism. To what extent is originalism a coherent phenomenon in a way that at least appeared to be earlier? And I guess I'll tell you my current thoughts on that are, and I had to think this through as I was working on the book, that the thing that has helped me evaluate the extent to which originalism is a coherent phenomenon is both there's a theoretical and then a practical part. So the theoretical part comes from the concept of a focal case, which I take from John Finnis, and in particular the beginning of his seminal book, Natural Law, Natural Rights. And then the other theoretical component is from Larry Solom, who's identified what he describes as a number of core theses of originalism. So Finnis and the focal case idea is that both in the natural world and in the theoretical world, there are ways to describe phenomenon that are examples of the phenomenon that in their most healthy, most excellent version, and then there's marginal versions of that phenomenon. And one example would be an oak tree. There's hale, hardy, full of acorn versions of oak trees, and then there's the kind of scrawny marginal versions of it. And that, I think, fits a lot of what you're describing, what I'm seeing as well, which is that and this fits with what Larry has been describing, where Larry's claim, which I think is accurate, maybe with one possible exception that I haven't worked through yet, is that originalists are united around two core theses. One is the fixation thesis, and one is the contribution thesis. So the fixation thesis is that originalists argue that the Constitution's meaning was fixed when the text was ratified. And then second, originalists argue that officers following the Constitution have to follow the original meaning, and has to contribute to the outcome of those lawmakers' decisions. So for judges, it has to contribute to the holding of the case. And so when you combine those two things together, I think what it suggests is that there continues to be a focal case of originalism. And when you think of the different versions of originalism that are out there, you mentioned some: original meaning, original methods, original intent. All those folks are committed to both of those propositions. And in practice, when you scan through the list of people who are self-described and widely recognized as originalists, and we talked about Randy Barnett and John McGinnis and Mike Rappaport, they also are committed to that second proposition, that the original meaning contributes to the outcome of judicial decisions. And in fact, one of the things that makes originalism so potentially challenging to non-originalists and to American legal practice is that, for the most part, originalists pretty robustly embrace the contribution thesis because, for example, Professor Barnett famously, or depending on other people's perspective, infamously, has argued that the Constitution's original meaning should trump all non-originalist precedent, and which could have, critics argue, dramatic destabilizing. So I think there is a lot of debate in originalism. The debate is typically around the margin, not the margins, but about what the focal case means and how it plays out outside the focal case. But it's
talk about that. A lot of people will say focal case. Be more concrete there.
Yeah. So the focal case is the fixation thesis and the contribution thesis, or I think he calls it hypothesis. And so, for example, regardless of one's stripe of originalism, when you're trying to decide how should NFIB versus Sebelius be decided, or how should have Wickard versus Filburn have been decided under the Commerce Clause, Federal Commerce Clause power, that all originalists are committed to, we follow the meaning as adopted in 1789, and then and then judges should follow that when they're deciding Wickard or NFIB versus Sebelius. That's an example of a focal case. But then there's, I guess,
Okay.
things outside the focal case or debate about what should or shouldn't be in the focal case. For example, originalists disagree about how we understand the fixed constitutional meaning. So original intent people argue you look to the intended meaning, original meaning, look for the public meaning, and original methods you look for the contemporary methods of interpretation to identify the meaning when the text was ratified. So there's debate about how we understand the fixedness or the fixed meaning, but everybody agrees that there is fixed meaning, and then we should apply it in concrete cases.
So
And then thinking about go ahead.
question on, it's interesting too, though. You talk about the construction zone of many originalists that, and this is, of course, a widespread criticism of originalism, that the text itself is underdetermined. It doesn't speak. The law runs out, to use a phrase. The Constitution runs out, and a doctrine has to be constructed to make it coherent with all of these cases and challenges that are brought. Is the construction zone, does not the inherent need for a construction zone lessen the power of originalism? This is something that a lot of originalists contend is necessary. What do you say?
Yeah. So I'm of kind of two minds about this, and maybe that's just my disposition where I kind of end up in the middle on a lot of these issues. So on the one hand, it seems clear to me when I look around at other related human phenomenon like literature or communication generally, or law in particular, that I see situations of underdeterminacy. And so it would be surprising to me if one area of human endeavor that was exempt from underdeterminacy, where the phenomenon doesn't give us one right answer, would be constitutional interpretation. And so prima facie, I'm skeptical that there wouldn't be a construction zone. On the other hand, I share what you identified as a concern or criticism of originalists who have adopted a robust construction zone. You mentioned earlier Professor Balkin from Yale as being an example of that, because that I'm confident becomes a situation where the kind of minnow of construction swallows the whale of originalism's commitment to fixed constitutional meaning. And so what I try to do is I try to identify what I think is the reasonable insight for originalists who believe in a construction zone, which, as I described earlier, I think it's a fact of human life that many of our endeavors don't cash out indeterminate answers, and law is one of them, and the Constitution is also one of them. And I try to give some examples and reasons to think that that's the case, like, for example, the vagueness of language generally, or of law, or of legal terms in particular. And then I also try to identify ways in which I think that the construction zone is modest in scope. And here I rely a lot on the work, which I think was just really excellent, by John McGinnis and Mike Rappaport, talking about contemporary rules of interpretation. I would call them I think they call them original methods. I would call them rules of interpretation, which I think existed at the time the original Constitution was adopted and ratified, and also later, for example, with the 14th Amendment. And I try to identify what I think are three key closure rules of interpretation, that narrow what would otherwise be a prima facie broad category of construction. And just one example, this is one I borrowed from McGinnis and Rappaport, is that if a judge is faced with what he or she perceives as underdetermined original meaning, in other words, it doesn't seem to give him enough information to answer the legal issue before the judge, what the judge should do is rely on the best available evidence. So there's two parties before the judge. One is arguing the original meaning is X, one is arguing that it's Y, and what the judge should do is, like judges always do, pick the argument that is supported by the most, what I call legal evidence, the most arguments and historical evidence combined. And when you do that means that a large number of cases that would otherwise be underdetermined because you don't have maybe a 95% degree of confidence or a 100% degree of confidence become closed, become answered, because you have a degree of confidence that one party's arguments are more weighty than the other party's arguments. So to summarize, I think there is a construction zone, but I think originalism has built within it rules of interpretation that narrow it in a way that makes it acknowledge the underdeterminacy of the Constitution's original meaning, while making it that it doesn't undermine originalism overall.
George Will was just on this program to talk about his new book, The Conservative Sensibility. In that book, he has a chapter called The Judicial Supervision of Democracy, where he contends for something pretty similar to this idea of judicial engagement that one of the scholars you cite in your book, Randy Barnett, advocates. And George Will argues that really when we think about the Constitution, outside of the Declaration of Independence, second paragraph of natural rights, it really comes unbound and means nothing if it doesn't have that content anchoring it. And judges should interpret the Constitution in light of those natural rights. And just thinking the title of that chapter, Supervision of Democracy, does originalism point in that direction? I mean, and I guess another way to ask my question, where do we, the people, in the Republican accountable branches fit into originalism?
Okay, that's a good, it's a complex question. So on one point, Richard, what I would say is first describe how I would answer these two questions. So the answer to both your related questions, one of which is to what extent are judges authorized to protect natural rights through constitutional interpretation and their judicial power, and then relatedly, to what extent is popular democracy or the role of the American people play a role in their own self-governance are empirical questions within originalism, that it depends on what the Constitution's original meaning is, how it cashes out. Does it authorize, in fact, judges in the exercise of judicial power to utilize robust interpretations of natural rights? And you mentioned Professor Barnett. I think Professor Barnett has the strongest argument in the scholarship out there that the Constitution's original meaning is strongly rights protective, and my own, I haven't investigated that historical claim fully, but to the extent that I have, I think that it's most robust vis-a-vis the federal government, and that it's less powerful regarding the ability of state governments to govern their people. And so, on the flip side, what role do the American people have? I think originalism provides a really robust, and certainly a relatively more robust role for the American people in their own self-government than most versions of non-originalism. One exception I'm thinking of is Eric Siegel in his version of Living Constitutionalism. And how does originalism do that? It does that through a number of mechanisms. So one, of course, is, and I think Professors McGinnis and Rappaport do a good job making this argument, that a revivified culture of originalism would help Americans exercise their civic muscles and return to the practice, which I think is salutary and, although contentious, of doing Article 5 amendments. Second, a properly interpreted Constitution, I think, leads to lots of questions, lots of legal questions, lots of social questions that the Constitution doesn't answer. For example, abortion. I think what the Constitution says is that abortion is a states' rights issue within its area, and then slightly a federal issue on interstate issues. And so those would be areas where the American people, either through their state or national representatives, express their policy views regarding abortion. And then third, I think what originalism does is it creates a culture where Americans redevelop the habit of engaging with their fellow citizens on answering, either legislatively or not, in other words, leaving the issue alone, fundamental issues. And what I have in mind here is the issue of assisted suicide, which in the early 1990s, it looked like the issue of assisted suicide was going to follow the same route as abortion, where people were going to the Supreme Court, asking for the court to constitutionalize a right to assisted suicide. The Supreme Court in Glucksberg versus Washington famously turned that back. I think it was 1995. And since then, it's not that the issue has dropped off, it's that the issue has become a state-focused issue. And some states have embraced assisted suicide and euthanasia, and many and most states have not. But Americans have exercised their civic muscles in making those decisions. So I think it's an empirical question for natural rights and or American people's self-government. To the extent that I've looked into it, I think that originalism on the state level especially emphasizes the ability of Americans to govern themselves.
on, you make a claim in the book that originalism with regard to constitutional interpretation is our tradition. That's
Okay.
an interesting claim. Maybe talk about that some more.
Sure. So there's a lot of debate over to what extent are originalist claims today, in other words, the claim that we should follow the Constitution's original meaning in cases or controversies, is that consistent with the practice in the early republic? And I think where this arises is a misplaced criticism by living constitutionalists that if originalism wasn't the practice in the early republic, that would mean that originalism today was fundamentally and internally incoherent. I don't think that's true. For example, it could certainly be the case that even if the framers or ratifiers didn't recognize the value of originalism, if we today have sound reasons to recognize it, we should follow originalism. That's not the move that I make, but I think that's where this issue comes from. So there's developed a rich secondary literature talking about early interpretive practices. And the people that have been most persuasive to me are Christopher Wolfe, who's now at the University of Dallas, and Jonathan O'Neill, who I believe is at Georgia State, who have gone through the history of interpretation, beginning with pre-constitutional times, and like, for example, in English colonial times, up to today. And their claim, which is supported by copious citations and examples from the text and practices of the time, is that even though they wouldn't use the label originalism at the time, and even though it wouldn't be as sophisticated as people argue today, both the goal and the tools of interpretation in the early republic and continuing up until the early to mid 20th century were clearly originalist practices. And I think Professor McGinnis's and Rappaport's more recent work on the original methods is contributing to that. It's providing an additional, analytical tool to show that in 1787 or 1789, for example, if there was a debate about what the Constitution meant, one of the common moves among interpreters was to resort to these conventional rules of interpretation. And in fact, in a previous article, I went back to the debate in the first Congress over chartering a national bank, which was the biggest constitutional issue in the early republic. And what I saw was people prima facie disagreeing over whether the Necessary and Proper Clause authorized Congress to charter the first bank of the U.S., but all of them concluding, after using rules of interpretation that they all seem to agree on, that the Constitution did give a determinate answer to that question.
What do you think? So you read the first Congress debate over the Bill of Rights. It's pretty sparse, and yet the Bill of Rights has emerged. The meaning, the text of the Bill of Rights, particularly say the First Amendment. What would you do with that? I mean, you have pretty thin material to work with in terms of whatever you want to call it, original intent, original meaning. How would you sort of work through that? I mean, I think maybe the better move was, incorporating it, of course, magnified the importance, but I'm curious how you come out on that.
Yeah. So I've actually had a to the extent that I've reviewed for the original meaning, for example, the free speech clause of the First Amendment, I found it to be challenging, in part for the reasons that you gave, Richard. But let me step back and just talk a little bit about how one would go about trying to ascertain the original meaning of the free speech clause or free exercise clause. So one thing you would do, of course, would be you look to see how did contemporaries describe the meaning of those clauses. But originalism would also look to try and find the public meaning of the words and then the component phrases there. And the area that I've done actually kind of the most research on the First Amendment has been the free exercise clause. And I'm actually pretty confident that there's a right answer to both what the components mean, what does free exercise mean, what does religion mean, and then what does the clause overall mean. And it's not because of the robust debates in the first Congress, although I think they provide some evidence on that point, or the debates in the state ratification conventions, which we have very little evidence of.
Yeah.
But it's more the background public meaning taken from state constitutions, state laws, and the public meaning of the words themselves. And so I think the First Amendment is a relatively more challenging one than, let's say, commerce. So the Commerce Clause, I think that meaning has been clearly liquidated by originalists, both in the early republic but also today. And the Free Speech Clause, I think, is more challenging than the Free Exercise Clause. And there's actually some great scholarship going on that clause. And
Yeah.
it reminds me of one additional point.
What do you make of?
So
you used the word liquidate just then. What do you make of? So, and we're talking early Republican. You talked about the bank. James Madison's position,
yes.
where he clearly thinks it's unconstitutional on the text to have a bank. He loses policy wise. He loses in the court of public opinion, and he comes back later in his presidency, and you know, in his veto message, he acknowledges the constitutionality of the bank, not necessarily because he has been convinced, but because the people had liquidated the meaning and had determined that it was, in fact, and on that basis, the acceptance of the people, and over the course of elections, a judicial decision, that somehow this could now be reconciled with the Constitution. How does that fit in with an originalism analysis?
Yeah, so I think it depends on what we mean by liquidation, and that.
Well, the way Madison used it is kind of the way. I mean, the way Madison used it with regard to the bank, that the Constitution was liquidated through Republican practice, not necessarily through the techniques of, you know, academics using originalism. Because I'm
Sure.
familiar with I'm familiar with sort of the liquidation, like of Will Bott or others, but I'm not sure that's the way the founders meant it, particularly in the Federalist Papers.
Well, so I guess my view is on liquidation that it was widely accepted as a phenomenon, but I think, and this is what I mean by what we mean by liquidation, that it presupposed that there was underdeterminacy over the thing being liquidated. So I think, we may be disagreeing over whether what Madison's views were about the robustness of the determinacy of the necessary and proper clause not allowing.
Yeah, no, he never changed his mind. He thought the Constitution didn't allow it, but yet he relented on his view because he thought the people had chosen to accept it. And over time, that Republican process had not changed the meaning of the Constitution necessarily, but now allowed it to be acceptable in some ways. It's sort of a tricky description how he walks his way through it.
Yeah. And so I think that most people at the time would have described liquidation as, and I think this fits still with what Madison's description was of the phenomenon, that there was disagreement over the meaning of the necessary and proper clause. He had one view. He was confident in that judgment. Other people were equally as confident in their judgments. So it seemed like that was a situation, from Madison's perspective, of underdeterminacy that allowed the practices, so adoption through Congress, approval by the courts, to, quote, liquidate that meaning. I think it's a closer question, although I'm not sure, I don't have a firm view on this, of what if the Constitution had determinatively said X, and the meaning had been, quote, liquidated to not X. And that I don't see evidence for, or as much evidence for, in the non-judicial branches. So the research that I've seen so far suggests that the ability of a federal official to follow something different than the original meaning was limited to them exercising powers that authorized them to do that. And judicial power, I'm confident, allowed federal judges to follow non-originalist interpretations in some situations, but I haven't seen similar evidence that it would allow congressmen or presidents to follow non-originalist meanings. As a determinatively non-originalist meaning. So I think there is liquidation. I don't think its bounds extend tentatively. I don't think its bounds extend to determinate original meaning.
Yeah, well, that's interesting. The book is Greg Wiener's book, Madison's Metronome, where he kind of walks through this analysis that Madison had just recognized his understanding had been sort of dismissed through a public contest. I'm back on this point on what we were talking about, the traditional, that originalism is our tradition, and yet, Robert Bork, Scalia, other thinkers, other judges and legal thinkers are seen as almost counter-revolutionary type figures. I mean, that sort of
Mm-hmm.
sparks the question, okay, if it was our tradition, is our tradition, when did it go into eclipse and why?
Yeah. So the story that I tell is one that I think fits most of the scholarship on this point, which is that in the late 19th, early 20th century, for a variety of reasons, originalism came to not be the practice, or at least not the rhetorical practice, and in many ways the substantive practice of the Supreme Court. And I give a number of reasons for that. One area that I'm most familiar with, just because of my teaching, has been administrative law. And of course, the administrative state started to grow in the late 19th century, with the Interstate Commerce Commission being the first modern administrative agency, and then continuing in the progressive era, and then really flowering under the New Deal. And the administrative state was motivated by a number of political, ideological, and jurisprudential views, but it necessitated a non-originalist view of the Constitution, because I make the claim that you can't have modern administrative agencies that are consistent with the Constitution's original meaning. And so my argument is that by 1945, 1947, that originalism, certainly rhetorically and in many ways substantively, had ceased to be the practice of the Supreme Court and most of American legal culture. It became exotic to make originalist arguments, and but at the same time, the political landscape, the practice of Americans, and certain fundamental practices of the Supreme Court didn't change. So, for example, to my knowledge, there's not a case where the Supreme Court has said the Constitution's original meaning is X, and we're following not X today. That the Supreme Court consistently, at least rhetorically, says it's following the Constitution and its original meaning. Or we still follow this written document in the National Archives, which by non-originalist lights doesn't make much sense, and maybe it's in fact wicked to do so because of negative provisions and unjust provisions in it. And yet all federal officers take an oath to that document and identify that document as having come from a specific set of humans at a specific period of time. And my argument is that the writtenness of the Constitution, the provenance of the Constitution, show fundamentally that the underlying practice hadn't changed. And so that on the surface, there's been a lot of originalist overlay, but deeply, there continue to be fundamental originalist commitments of our practice.
But what about...
And so what more...
Yeah, no, but what about, say, the sociological jurisprudence of the progressives, most prominently in Brown versus Board of Education? I mean, do you find that to be an opinion where they're... I mean, it seems to me, yeah, there's the text, but what they're really concerned about is explaining to you just how bad unequal schools are, which I get that, but the reasoning there is, as many people have pointed out, not entirely satisfactory.
So I love teaching Brown for a variety of reasons. It's a very important opinion, of course, substantively. But one of the reasons why I like teaching is that I think it's an example. I don't even have to comment on it. My students are underwhelmed when they read the arguments. They expect some magnificent edifice of legal reasoning, and they're just, it's kind of like the same response I get when the students read Roe versus Wade. Even if they like the result, they're just really underwhelmed. But I think one of the key points of the reasoning that supports my claim in Brown versus Board is that the court first had to dispose of the original meaning of the Equal Protection Clause. And it didn't do it by saying they were reaching an opposite result. What the court said was that the original meaning was indeterminate on this point because the phenomenon of public education and racially segregated public education was new and something the framers hadn't envisioned. Now, putting aside whether those claims are right or wrong, what that showed was that the court was claiming the original meaning was indeterminate and therefore gave it rein to utilize, in its view, these other tools of legal analysis. So I think Brown is consistent with, on that fundamental level, originalism. And I also think the outcome is consistent as well. But fundamental, even though the rhetoric is not, as you were pointing out, Richard.
So in this connection with tradition and originalism, you argue in the book, you take on arguments in the book that originalism would lead to unjust outcomes. That's the argument of many opponents. And/or there are sins widely regarded in the American past, and originalism couldn't, resolve those in a way that public opinion would accept. and that's a mark against originalism.
Mm-hmm.
Prominently right now, we've just had the New York Times, 1619, argue that our country is built on slavery, basically. This would be one of them. And of course, we see a progressive jurisprudence or progressive scholarship. There's this move to tie more and more provisions of the Constitution to protecting slavery. How would you respond to all of that?
Yeah, so I think there's certainly some truth to the claim, and in some cases a lot of truth to the claim, that at different points in time, the Constitution's original meaning had been and led to and perpetuated unjust relationships between human beings. And slavery is the kind of keystone example for that. And so if you were to ask me in 1862, for example, whether we should follow the Constitution's original meaning, what I would say is we can ascertain it. If you take an oath to uphold the Constitution, you're obligated to do it. But at the same time, I would question whether one should enter into federal office and take on that obligation because of the perpetuation of that institution of slavery. But that's not today, right? And instead, my argument is that the Constitution's original meaning today creates a basically just legal system, not perfectly just, certainly not by my own lights either. There are a lot of things that I would like to have changed in the Constitution's original meaning. But more fundamentally, what I argue, Richard, is that the argument that one should judge an interpretive methodology by the policy results or substantive results that it cashes out is a misplaced view. That we don't view, and I certainly don't teach my law students to view, law and the legal process and the judicial process as being solely or entirely or even mostly about the substantive results. And what I try to do is I try to tie a picture of law as coordinating Americans and then tie that to the Constitution. And just like the broader American legal system or the legal system of Ohio, where I'm at, creates a basically just legal system, and therefore officers who are members of that legal system and swear an oath to that legal system should follow it because of the benefits that Ohio's legal system provides. Similarly, because of the benefits that the American legal system, fundamentally resting on the Constitution, provides, that judicial officers have sound reasons to continue that basically just legal system. So I'm acknowledging certainly historical and even current injustices in the original meaning, but that's not our standard for judging interpretive methodologies. Instead, what we say is that in interpretive methodology, the interpreters have sound reasons to perpetuate the basically just legal system that their interpretations are a part of.
Many would argue, cynically perhaps, originalism, though, always has to find a way to accommodate hard cases, like Brown versus Board, which say Ray Olberger said was unconstitutional under an original intent analysis. And an originalist sort of, but then the famous law review article of Michael McConnell helped everybody get right. Isn't originalism, though, going to have to do the same thing with Obergefell v. Hodges?
That's a great question. One of the things I find interesting is that there's a lot of original scholarship. Not much attacks if any, I'm not actually aware of any, attacks the originalist bona fides or lack thereof of Obergefell versus Hodges. There's scholarship, for example, by Stephen Calabrese that suggests that Obergefell is consistent with the Constitution's original meaning, although I frankly just don't find those arguments persuasive at all. And maybe the reason why there's not much
does Calabrese, Calabrese is one of the founders of the Federalist Society.
That's right.
And this is
which supports your point, right?
An originalist. He's an originalist, right?
Yeah, and
of some kind.
In fact,
of some kind. So yeah. I mean, I just, it seems to me, I don't think there's any way. Well, I don't know. I mean, I can think of some originalists. Well, yeah. I mean, a lot. Like so, the Volokh conspiracy writers love the result. They criticized it in various ways. But you know, it's a problem. It seems to me it's inherently the political thing comes out, and originalism has to find a way to accommodate it. How do you see that?
Yeah. So on the one hand, when I think, so what's a legal system's purpose? A legal system's purpose is to provide a mechanism for people to live together as well as possible. And legal systems are run by human beings who make mistakes. sometimes unintentionally, sometimes intentionally. And Justice Kennedy authored Obergefell. I think it's inconsistent with the original meaning, and I don't know if intentional, whatever. I don't even know if he cared about what the original meaning was. And so any viable legal system that's trying to help people live together is going to have built into it a mechanism to account for mistakes. And originalism has that mechanism primarily through a theory of non-originalist precedent. And so I guess I push against the premise of your constructive criticism that if originalism is able to accommodate non-originalist decisions, or it seems like it does all the time, that's somehow a flaw. I think it's only a flaw if the accommodation undermines originalism's fundamental commitments. Because otherwise, I think that originalism actually is virtuous from having accommodated some or many non-originalist precedents. And in fact, one of the, I think, reasonable criticisms of Professor Barnett's view of originalism is that his view would lead to dramatic destabilization of the American legal system because of so many decisions being overruled in such a short period of time. And in fact, he recognizes that, right? So in some of his scholarship, Professor Barnett has argued that judges should slowly overrule the non-originalist precedents using their equitable powers. But that's not that argument there is under-justified. And so I think even people within originalism who would be sympathetic to your view, which is that originalism gets co-opted over time or has to fit with political or policy views, recognize that to be a functioning interpretive theory for a functioning legal system, it has to be able to account for mistakes, and I think originalism does. But at the same time, it has to have a mechanism that it doesn't accept everything, right? Because then it becomes what you said, which is just another political manifestation. And so what I've argued is that judges have an analysis. It's not determinative. In other words, reasonable people could disagree. That takes into account three factors. One is, to what extent is a decision, Obergefell, Brown, Roe, whatever, inconsistent with the original meaning? Second, to what extent would overruling the decision harm rule of law values? And then third, and this is maybe the most provocative part of the analysis, to what extent does the decision under consideration reach normatively attractive results? And of course, people are going to disagree on that third point.
That's just like justice, right? The good.
That's right.
Yeah.
That's right. Okay. So does Brown, does Roe, does Obergefell create just relationships between Americans, or does it detract from it?
Yeah. Switching gears here, you also write a lot about Aristotle in this book, which I find interesting. A lot of others will find interesting. So does Aristotle help us think or bolster our thinking about originalism?
That's really good. And there's lots of different individuals that I could have relied on. And what I try to claim is that this way of approaching philosophy, this Aristotelian philosophical tradition, starting with Aristotle, I think Thomas Aquinas was the great synthesizer, and then their modern exponents, John Finnis, Robert George, and other people. So I try to look at this body of thought set in motion by Aristotle, for the most part being faithful to Aristotle's description of humans and human society. And so, does Aristotle have something to say about originalism? The answer, I think, is clearly yes, because he has something to say about humans living together in both parts, right? He has something to say about what it means to be fully human, and he describes the ways in which, for example, justice is both an internal virtue, but also a norm that humans should follow in their lives and in their interactions with each other. And so I translate that over into a conception of the common good that the American Constitution's original meaning is the key mechanism to help Americans today pursue. So Aristotle got a lot to say about originalism.
Okay. Oh, good. Well, I like that. Lee Strang, thank you so much for joining us today to talk about your new book, Originalism's Promise, a natural law account of the American Constitution. This has been lovely. I appreciate it.
Thank you so much, Richard. Those are great questions.
This is Richard Reinsch. You've been listening to another episode of Liberty Law Talk, available at lawliberty.org.